This conference will now be recorded.
Bear with me. This slideshow is needing to be corrected. 1 second. Okay, so welcome. It's Friday, February 5th, 2021, and today's topic is 3 solutions to protect the Florida homestead when the homeowner needs long-term care. So no surprise, we are all aging, especially during this last year, this challenging time of living through the COVID virus, not only in our country, but in many countries around the world. So I thought that today's topic is something that is on top of a lot of people's minds, simply because the home is probably the most important asset that everyone has. We save while we work to buy a home, we pay down the mortgage, and we look forward to the day that we own it free and clear. And for many people, they are going to stay in their home the rest of their life. And the hope is that they'll be able to receive the care they need at home rather than to reside in a community or a facility. So we're going to start today's discussion by talking about what exactly is long-term care and some current aging statistics. So long-term care means 2 things. Number 1, activities of daily living, which you might see abbreviated as ADLs. And activities of daily living are things that right now, when we're all healthy, we may take for granted. It's our ability to groom ourselves, that we take a shower, brush our teeth, brush our hair, practice good hygiene habits. Our ability to be mobile, whether it's walking independently, walking with assistance, which could be a walker or a cane. It's our ability to eat independently. It's our ability to transfer from the bed in the morning to maybe a chair that's nearby, or from a chair at a table to a wheelchair so that we can move around our home. It's our ability to go to the bathroom independently. So those are activities of daily living. When a person is unable to perform anywhere between 2 and 3 activities of daily living independently and they need assistance or they need cueing, that is a good sign that somebody is in need of long-term care services. The other thing that we look at to determine if a person needs long-term care services are what are referred to as instrumental activities of daily living, IADLs. An example of an instrumental activity of daily living is the ability to prepare our meals, starting with first going shopping, buying the food, and then preparing it. It would also include the ability to remember how to use a telephone, to go through the mail, read the mail, pay bills on time. So both these types of activities of daily living are very pertinent to being safe in our environment and being able to manage making medical decisions as well as financial decisions. So the more activities of daily living or instrumental activities of daily living that we cannot perform independently points us in the direction of needing long-term care services. And services can be provided through a licensed home health agency, It might be through a certified nurse's aide assisting in the home, or a certified nurse's aide if we have certain medical issues that require attention by somebody with a medical license. We might then need a registered nurse or a licensed practical nurse to come to the home. Now, current statistics are telling us that people who are currently age 65 have a 70% chance of needing long-term care services in the near future. At age 65 happens to be one of our fastest growing age populations in the US. The other fastest growing age population is 85 and above. And what statistics are telling us based on census data is that by the year 2040, we are expected to almost double the number of people in that age group. We also are learning that women do tend to live longer than men, and as a result, they need long-term care services for a longer period of time, about 3.7 years, whereas men require it for about 2.2 years. And a third of people that are age 65 or older may not need long-term care services. However, 20% of that group will need it for about 5 or more years. And you're welcome to go to the United States Department of Health and Human Services to their website where they have this data. So being aware allows us to make informed decisions, and it enables us to be better prepared for our future. So what do we do with this information, especially if we have a loved one or a friend or a colleague that perhaps is starting to show signs of needing long-term care services? Well, the issue becomes, how do people pay for long-term care? And if people have not planned financially, they're going to find that their assets won't last very long, especially if they're paying to have care provided in the home environment. So it's very possible that people may turn to certain federal programs, such as Medicaid, to help pay for the cost of long-term care services. So today we're going to focus on how do we facilitate people meeting the eligibility standards while simultaneously helping them preserve the home, which is the most treasured asset. So Medicaid is a federal funded program in which the federal government provides funding to the states. In Florida, we receive about 3/4 of our funding from the federal government, and the remainder is provided through our state Medicaid budget. To qualify, a person has to have limited assets and limited income. And the reason for this is that when the Medicaid program was created in the 50s, early 60s, we only had 2 categories of economic classes. We had the wealthy class and we had the poor. We really didn't have middle income just yet. So as a result, the reality was wealthy people were able to privately finance their future long-term care needs. However, people considered to be in the lower economic class didn't necessarily have the funds, and employers didn't always offer health insurance as an employment benefit. So these people needed the assistance of the federal government to provide for long-term care services, hence the requirement of having limited assets and limited income. So the government, when looking at a person's application, looks at marital status because there are differing amounts of resources that can be kept depending on marital status. If the person applying is unmarried, they're allowed to keep $2,000 of countable resources. And in a minute, I'm going to explain what are countable resources compared to non-countable resources. If the person applying is married, they also are limited to $2,000 of countable resources. However, their spouse, who is not in need of long-term care, is allowed to have a higher sum of $130,380. And the reason for that is there is an expectation that the government honors that the community spouse, the one who's healthy, should be able to maintain the home and have a certain lifestyle. Now, there's also in Florida a monthly gross income requirement in order to qualify for Medicaid. Not every state has this requirement, and we are unfortunately one of the dying breed of probably less than 14 states that require limited income. In Florida, our monthly income limit is $2,382, and income is comprised of things such as our Social Security retirement or Social Security disability benefit, any pension from employment, IRA or pension 401k distributions, as well as interest or dividends that might be earned on our savings. And the thing to keep in mind is that the government looks at gross income, meaning before there are any taxes taken out or other deductions. Now, countable resources are things such as our bank accounts, our checking, savings, money markets, certificates of deposit, as well as savings bonds, whether they are government bonds, municipal bonds. It also includes any type of investment accounts, whether they are stocks, mutual funds, and regardless of whether they are individual stocks or stocks within an account. So those are examples of countable resources. Now, Florida has very good, strong protections when it comes to Medicaid. So we do provide more exempt resources than a lot of other states in the country. And exempt resources means that although they have a value to them, the Medicaid agency will not count them as a resource when deciding if a person qualifies for Medicaid assistance. For example, we exempt up to 2 automobiles in the state of Florida. We also exempt a certain value on funeral arrangements, and we exempt any distributions that are taken on a monthly basis from a person's IRA or 401k plan. So Florida, compared to other states, has a lot more protections. Now, wherever you are located in the United States, remember that Medicaid is a federal law. So the one important rule that applies no matter where the person lives is that there is a 5-year look-back period. And what this means is that when you fill out a Medicaid application, you will be asked the question, have you given away any assets within the prior 5-year period? And you must report it accurately, providing the month and year and the amount of the asset or the gift that was made. As a result of making gifts within 5 years of applying for Medicaid, the Medicaid agency will determine that the applicant is not eligible simply because the theory is that had the person kept the asset, they would have and could have used it to pay for their long-term care. So the application is denied and a penalty period is assessed. And what that means is it's not a monetary fine that is paid, but rather it represents a period of time that the individual must wait before they are eligible to have Medicaid pay for their services. The amount of the penalty period is calculated based on the value of what was given away. And there is a math formula that is applied to determine whether that equates to days, weeks, months, or years, or any combination. So now that we know the basic Medicaid financial eligibility rules, let's talk about the home. And Florida is one of a handful of states that treats the home as an exempt resource under certain conditions. Now, Florida has built into its state constitution homestead protections. And it's for this reason that when a person needs long-term care services outside their home and must go into either an assisted living facility or a skilled nursing facility, their home is protected. And it remains protected the entire time that they are on Medicaid. Well, what does this mean? It means that nobody, including the Medicaid agency, can ever tell that person to sell their home. Their home is protected. It is an exempt resource. Now, several years ago, the federal government gave the states the option of putting a limit on the value of the home in order for it to remain exempt. So for this year in Florida, that home equity interest limit is $603,000. If a person has an outstanding mortgage, then the equity interest is reduced by the outstanding balance on the mortgage debt. So as long as the value of the home is below this, it is completely exempt. It remains protected while the person is on Medicaid. And more importantly, when the individual receiving Medicaid assistance passes away, there will be no Medicaid lien imposed against the home as long as the owner is either survived by their spouse or a relative who will inherit the home. Unfortunately, that protection will not be provided to anybody outside the family. So, for example, if we have somebody that chose not to get married, but has been together with their life partner a very long time, yes, they can leave it to the life partner under their last will and testament, but unfortunately, the Medicaid lien will be able to go against the home. So you can see how planning in advance for these types of issues is so important. Now, what if somebody does need to go into a facility to receive long-term care services? How does that impact Medicaid protecting the home? Well, very simply, on the application, we indicate that the homeowner intends to return home. Now, this does not need to be physically or medically proven. It's just the intention that the person has to go back to their home. And that by itself continues to exempt the home from being an accountable resource. Alternatively, when there is a community spouse, a spouse who's healthy, still living in the home, that's another basis for treating the home as an exempt resource. Alternatively, if somebody does not have a spouse, but they have a blind or permanently disabled adult child, that's another basis for protecting the home while they are receiving Medicaid assistance. Now, we have many great rules, laws, and planning options in Florida, but notwithstanding those, we always have to look at practical challenges and figure out what is the best plan, the best solution to get to our goal. So challenges that we face are the fact that when a Medicaid recipient is receiving services in a facility, such as assisted living, or skilled nursing, the law requires their income to be remitted to the facility. It's what is referred to as the patient responsibility. Now, they are allowed to keep about $130 each month from their Social Security benefit as an allowance for their personal needs, but the balance has to be paid to the facility, which means that income is not available to pay operating expenses such as real estate taxes, homeowners insurance, flood insurance, or utilities. So we have to deal with the practical challenges of how can we keep the home, and does it make sense to keep the home, and if we have to sell it, what can we do to protect the proceeds so that the homeowner still continues to be eligible for Medicaid? And as I mentioned a minute ago, we always want to think about probate. Probate is the court process by which an asset goes from the deceased owner to the beneficiary. So we want to make that process as easy as possible as well. So together we're going to explore the top 3 planning options for this challenge. Solution number 1 is what I call the caretaker child exemption. Now, this is a wonderful tool that the federal and state government give us when we have the right set of facts. So essentially, what we're looking for is if an adult child has been living in the parent's home for 2 years prior to when the parent needed to go into a facility, there is a good likelihood that we can make the argument that by living in the home and helping to care for the parent, it delayed the parent needing to go into the facility, which meant that the state and federal governments didn't have to pay as much for long-term care services. And in essence, the government got a good financial result. Now, what they're looking for is referred to as substantial care. So what is that? Substantial care would be, for example, that the adult child is providing assistance with activities of daily living. Remember, we began today's webinar by talking about the ability to bathe, to groom, to transfer, to toilet. If the adult child is assisting the parent with those activities, that equates with substantial care. It might also be that the child is performing housekeeping services. They're doing laundry, they're doing cooking, they're doing cleaning, they're doing food shopping. It can also include activities such as overseeing and coordinating the parent's care, speaking with the doctors, bringing the parent to the doctor appointments, even coordinating some visiting nurses or occasional care from a home health agency. All of those are possible examples of substantial care. So the caretaker child exemption means that if we can document that type of care was provided for a continuous period of 2 years before the parent went into the facility, then under the law, we can have the parent transfer ownership of the home to that caretaker child. And so this is one of the exceptions to that 5-year look-back period that I just spoke about. This does not cause any type of disruption in qualifying or continuing to qualify for Medicaid assistance. So in order to properly document and prove that we meet this requirement, we would first start by contacting the client's physician and asking the doctor to go through the patient records to see when did the physician first diagnose the patient with their illness or disease, what tests were conducted to arrive at that medical opinion. And so we would want to then, from there, prepare an affidavit or a certification for the doctor to sign that explains that the doctor has been treating the patient when the doctor diagnosed the patient with the illness, and how the illness has affected the patient's ability to care for themselves. Then we want to have affidavits to corroborate that. And so we would want an affidavit to be signed by the caretaker child that would go into detail explaining when did that adult child move into the parent's home and why, what were the circumstances that led to that. In some cases, it might be that the spouse of the parent died, and then the parent became ill, and there was nobody else able to care for the parent, or it might be some different circumstances. But in that affidavit, we want to detail all the different services that are provided on a recurring, consistent basis by the caretaker child to the parent. And we want to talk about how that was a positive benefit to the parent because it delayed needing a higher level of care to be performed in a licensed facility. I also find that it's helpful to ask for an affidavit to be signed by somebody who is a disinterested witness. And what this means is somebody who's not the caretaker child, somebody who's not the parent, but somebody who knows them on a personal basis, is aware of the parent's illness and limitations, and as a disinterested witness who has no personal stake, they can corroborate the information that is in the child's affidavit and the parent's affidavit. Now, if the parent is mentally competent, then we do want the parent to sign an affidavit as well. If the parent is not competent, then we work with the other three, the physician, the child, and the disinterested witness. So this then enables us to prepare a deed to transfer the ownership of the home out of the parent's name to the child who's the caretaker. There is no loss of Medicaid assistance. And one of the other benefits is we now don't have to probate the home when the parent passes away. And as I said earlier, there will be no Medicaid relief. So this is one of the first things we want to explore when meeting with a client to discuss how are we going to help that client pay for long-term care services. A second possible planning option is renting the homestead. If the person is not at home any longer and needs to receive services in an assisted living facility or a skilled nursing facility. Now, you might remember earlier I said that one of the reasons in Florida that we exclude the home as a town of a resource is that we simply can say on the application that there is an intent to return home, not that the person must physically prove they're capable of returning to the home. So when we consider renting the homestead, we really want to rent it for a short-term period because we don't want to interfere with demonstrating the intention to return. So a short-term rental would mean 1 year or less. We would not want to do any longer than a year. And we would simply explain this to the tenant, even if we do an initial 6-month lease, that we would plan to renew it at the end of that period. Now, because rental income is counted, we want to be careful that that rental income when added to the other sources of income, such as Social Security benefits, pension, IRA distributions, that it doesn't put the person over Florida's Medicaid income limit. So we are allowed to deduct from the rental income the operating costs. Remember, we talked earlier about we need to keep the home insured. We have to have homeowners insurance or flood insurance. We need to be able to pay real estate taxes and utilities. Well, good news, we're able to deduct all those operating expenses from the rental income to arrive at the net rental income. And that's the only sum that is actually going to be counted to the Medicaid recipient. So we're not necessarily looking here to get a windfall and to make a profit by renting a homestead, but rather the idea is to be able to cover the operating expenses. If it's just clearing and covering the expenses, but there's really no net rental income, that's fine. We just have to show the documentation, which would be the lease agreement and the operating expenses to the Medicaid agency so they understand what is the net rental income. And so we still achieve the same result, which is that the home remains an exempt resource. We're no longer having to be concerned about how are we going to pay for the upkeep and care of the home. And we'll address the issue of avoiding probate by preparing a deed that some people refer to as a ladybird deed. And what it means is that the homeowner remains in control. They are the sole owner of the property. However, the deed includes language that says when the homeowner dies, it will be inherited by the people that are named in the deed. And so that's a very creative way that we can achieve maintaining Medicaid eligibility, as well as avoiding the probate process at the death of the homeowner. Now, what if we don't have the right set of facts to pursue the caretaker child exemption, and we're not sure that renting is going to be the right solution? So as I said, we always have to look at things practically. And it might mean that we have to look at the third possible solution, which is selling the home. Now, the first thing to understand is that if you sell the home, you are taking it out of its protected status of being an exempt resource. And now the closing proceeds that you receive are a countable resource, which most likely is going to put people over the $2,000 resource limit. So here are some planning options we have depending upon your age. If you are under age 65 at the time the home is sold, you can create, with the assistance of an elder law attorney, what is called a special needs trust. Now, this is allowed under federal and state Medicaid law because there is a requirement that in the trust document, it must state that when you pass away, any monies remaining in the special needs trust will first repay the Medicaid agency for all the Medicaid assistance it has paid on your behalf to providers, whether it be the facility, doctors, pharmacy, or therapists that provided services to you. Then after the Medicaid lien is satisfied, if there are still any monies left in the trust, those can be distributed to whoever you name as your beneficiaries. So we're allowed to draft an individual special needs trust for anybody under age 65. There is no rule or requirement as to how far in advance of applying for Medicaid this trust has to be created. And it can be created for somebody that's already receiving Medicaid assistance. So timing is not the issue. We have to focus on what is the person's age. So we could put real estate proceeds into a special needs trust and be able to allow somebody to continue to qualify for Medicaid assistance. Now, what do we do if somebody is already over age 65 and the law says we can no longer write an individual special needs trust tailored to that person? So our second option is what's called a pooled trust. So like the word pooled means, it is a trust, one trust that is already in place, and multiple people from around the state can pool their monies into the trust where a separate account is maintained for each person. Now, every state can have multiple pool trusts. The only requirement under the law is that the pool trust must be managed by a charity. It cannot be managed by an individual, which simply means that a family member of the person receiving Medicaid cannot be the trustee. The trustee is a charity. In Florida, we have many different pool trust companies, and each pool trust has a different charitable purpose. So how you determine which pool trust is right for you may very well have to do on the rapport or the connection you feel to that charity's and what its purpose is. For example, there are some pool trusts that have a connection with a certain religion. Some may be Christian-based or Jewish-based. There are other pool trusts whose charitable purpose is to work with children. Other pool trusts have a charitable purpose of working with people of any age who have a disability or an illness. So there are many different pool trust companies to choose from in the state of Florida, and each of them will have a similar administrative fee for administering the trust, which means they are investing the monies, they are reporting to the pool trust account owner, and they are each year providing a written accounting of the income earned by that account, as well as the monies that were spent on behalf of the individual receiving the Medicaid. Just like with the special needs trust, there must be a provision that says upon the death of the trust beneficiary, Medicaid's lien must first be satisfied. Now, what kind of things, services, or items could a special needs trust or a pool trust be used for to benefit the person who's on Medicaid? Well, the answer is that we can use those monies for anything that is going to improve the person's quality of life or quality of care. And that's different for everyone. So, for example, when a person is on Medicaid in a facility, Medicaid will only pay the facility what is referred to as a semi-private rate, meaning the person will be sharing a room with one or two other individuals. So if instead they would like to have a private room, then the special needs trust or pool trust would be used to pay for the difference between the semi-private room rate and the private room rate. If a person needs additional care, we could also use the monies in the trust to pay for private duty home health care. We can use it for anything that is going to give the person better quality of life, and that could mean recreational. That could mean a television of their choice. It could mean any kind of electronic device like an iPad or a laptop. And to some extent, there is also the ability to pay or reimburse certain family members to come and visit with their loved one. So there's really no limitations but actually a continuing list of things that trust assets can be used for that give each person quality of care and quality of life. So I'd like to leave you with some tips to help you after today's webinar prepare for your future. And number one on my list is that everybody, no matter what age, should have a legal plan that includes documents creating a management system so that when you become incapacitated, either physically, cognitively, or both, that somebody you trust can continue to make your financial decisions as well as your medical decisions. And the advantages of having this legal plan is that, first of all, you choose who makes those decisions for you. It means that we keep your life private, and we're not going to court to have a child or family member be appointed your guardian, which can be time consuming, expensive, and results in a certain loss of privacy. The other very important advantage to having a legal plan that includes a durable power of attorney is that in that document, we will write language that allows the person you trust to do Medicaid and long-term care planning for you if you don't do it before you become incapacitated. So what that simply means is you'll still have planning options available even if you can't implement it yourself. Whereas for people that never signed a durable power of attorney, or their durable power of attorney was not well written because they didn't go to an elder law attorney, they might have fewer planning options because the necessary language is not in the document. My second tip, especially for those of you that are still young enough to obtain it, would be to purchase long-term care insurance. The younger you are, the lower the premiums are for the insurance. And the benefit, not only financially, is that you can decide what you want your long-term care plan to cover. So you could select to have the insurance pay for services in the home. And that's very beneficial. You get to exercise choice and control. My third tip is work on your financial plan. Meet with a financial advisor who can help you maximize what you have and help you to understand the value of money and what will you need when you retire to live on. It's also important to think about and plan where you're going to live. You know, when we're younger, we're not necessarily thinking about, am I going to be able to climb the stairs or go down into the basement when I'm in my 70s or 80s. So it is important to think about the type of home you want to live in, especially if your goal is to age in place in your home. And if you live out of state and you're not near your children, then you want to think about hiring a qualified care manager, somebody who's a social worker or a nurse by background and training, to help you from a distance be able to oversee the care that your parents receive and to be able to coordinate services between your doctors, a home health agency, to avoid any problems occurring. So how do you plan in advance? Well, you plan in advance, first of all, by finding a qualified elder law attorney. You want to ask that person how many years of experience they have, what percentage of their law practice is devoted to elder law compared to other areas of practice, because that's going to tell you if somebody's trying to be a generalist, trying to dabble in this, who isn't going to be up to date and know the rules and laws and the changes. You also want to ask whether the attorney is board certified, which means they've had to continue their education process and they've taken a test to establish that they have an expertise. You also want to ask the attorney's office when you call, is there a consultation fee? Will I receive in writing a proposal for services after I discuss with the attorney my concerns and my goals? And don't be shy, ask for a reference, ask for a client that has been satisfied with the attorney's services. You can also read about the attorney's profile on the Florida Bar website. You'll also be able to tell from the bar's website whether the attorney is board certified in elder law or another area. And if the attorney is a member of the National Academy of Elder Law Attorneys, you can go to the NALA website to learn more about the attorney as well. You certainly want to look for a website for the attorney, and on the website, look to see if there are client reviews. What do those reviews say? If you don't see reviews on the attorney's website, you can look for reviews on Google, Facebook, and Yelp. And most importantly, you want to base your decision on the customer service experience you receive. Are you comfortable? Have you had all your questions answered? Did the attorney take time to listen and listen more than they talked? And of course, you want to be assured that the information you're sharing is being kept confidential and secure. So at this time, I'd like to open it up to questions. You're welcome to unmute your microphone or use the chat box feature. So if there are no questions, I want to remind everybody that I host these webinars 2 times a month. You can go to the website, to the events calendar page, where we list out upcoming webinars where you can register. And if you are not able to attend a webinar, don't worry, just go to our webinars page and you'll see a listing of all the recorded webinars, which you are welcome to watch in your own time in the privacy of your home. And I encourage everybody to go to the Contact Us page of the website, where there is a gift certificate you can use to encourage you to make either an estate planning consult or a long-term care planning consult. Jeff, do you have a question?
I did. I just took a while to get my mic unclicked and get my thought together. So when you're, I think a couple assumptions are that, eventually, Medicaid is the way to go. And, whatever your income is, it's going to go to pay for that. And you have to get below the threshold of only having $2,000 or less and countable resources. And then you don't have to really worry about them coming after the house if it meets one of those parameters that were on that list.
Correct. And if the home is going to be inherited by family, the home remains protected at death.
Say that one more time.
As long as the home will be inherited by a family member, it is protected at the death of the homeowner.
Okay, so it could be vulnerable when the person dies if a family member is not living in there?
No, I didn't say not living in there. I said as long as a family member is the beneficiary who will inherit it.
Okay, so if you're on the deed with rights of survivorship, joint tenancy, that counts?
Correct. The home would remain protected at the death of the Medicaid recipient.
Okay.
Well, thank you. I appreciate everybody who took time out of their day to join me today. I hope you found the information helpful. My number is 954-382-1997. My staff and I are here to support you through all the aging challenges that you encounter. And I wish everybody a healthy and happy weekend, and I hope to see you again soon.